All right, we are live today. I was going to actually record a episode, podcast and video here for YouTube, but I decided, you know what? Let's try going live. Hopefully, my audio is working and I have this all set up properly because I haven't gone live before. So this is a first. So today's kind of like a hodgepodge of different things that I kind of wanted to talk about and touch on. And the first thing is going to be about the Uniform Unincorporated Nonprofit Association Act. That is a mouthful. And of course, my phone is ringing. So let me just put that on vibrate. So, um, yeah, and if you're jumping on and you happen to see this, feel free to leave a comment in the chat and I will definitely answer for you. But as always, none of this information constitutes as legal or tax advice. So now that we got that little disclaimer out of the way, what is the Uniform Unincorporated Nonprofit Association Act? And man, it is loud by the office today with all these trucks going by. So basically, this act came out in, I believe, around 1996, and it has to do with nonprofit unincorporated associations. And basically, it came out with a legal protection and benefits for these nonprofit associations because each state was looking at them differently. And there's all these different common law rules and different rules depending on what state you go to. So whenever I or any of the people I work with in regards to associations talk to anybody, we always use that word, it depends. And it depends on where you are. So that being said, as of September of 2021, this is the most up to date information I can find. And always double check your areas. You can look in your state statutes, stuff like that, probably your state website. You can just type in, the unincorporated nonprofit association. So, that being said, there are 43 states that recognize it, including the District of Columbia. So, I guess I'll just run right down those for you. So it's Alabama, Alaska, Arizona, Arkansas, Colorado, Connecticut, District of Columbia, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, Missouri, Montana, Nebraska. I feel like what was that show? Animaniacs. Let's see, Missouri, Montana, Nebraska, Nevada, New Jersey, New Mexico, North Carolina, North Dakota, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, Virginia, West Virginia, Wisconsin, and Wyoming. So those are the states that recognize the Uniform Unincorporated Nonprofit Association Act. Now there are 7 states that don't, and that's going to be Delaware, Georgia, Maine, New Hampshire, New York, Florida, and California. Now that doesn't mean that those states don't recognize unincorporated associations. That's just for that Uniform Unincorporated Nonprofit Association Act. Man, that's a mouthful. So if you happen to have a nonprofit association, then you might be able to use that act to your benefit as far as being seen as a legal entity in your state. Now, you will, all 50 states recognize unincorporated associations, but it does depend on the state that you're in, whether they see them as a legal entity or not. So a lot of this information you can find over in East Coast PMA, or if you head over to the PMA manifesto, that information's also over there. So that's kind of just that act in a nutshell. In my course that I'm putting together, there's actually a download for it that really is the whole act. So you can read through it if you really want to. And I think there's some good information there, especially if you were going the nonprofit route as an unincorporated association. So the other thing that seems to have been coming up this week in conversation has to deal with some of the court cases that go along with what others in the association world put out there. So um, I figured why not kind of dive into these a little bit and look at it from a tabletop view, I guess. And so these are ones you've probably seen on other websites. So it's going to be Meyer versus Nebraska. Um, let's see. We have the United States. I don't even know why I don't have it on here. Where is it? Pierce versus Society of Sisters, and then the other one is Roberts versus United States of the JCs. So these indirectly affect associations, I guess is the best way to put it. And when you go to other websites, they pick and choose what they want out of here to kind of give that false safety of security that the unincorporated association can never be challenged, and that's just not the case. There's absolutely nothing that I know of that can keep the government from ever challenging anything that you're doing, especially if you're doing something illegal. So, what was interesting about the and I guess the term that you want to, if you wanted to search for, you can look for is sanctuary from unjustified interference by the state. Now, if you go through and you brief this case, this is Roberts v. United States JCs. Basically, what it was a men's group, and they had I want to say like 4,000 members or something like that. And basically, they were only allowing men in, but it was any men. They weren't really descriptive or inclusive to who they were letting in. And then in Minnesota, there was some chapters that started letting women in, and then this became an issue because the national level of the JC said, "Hey, we're going to pull your membership rights or what have you because you're allowing these women in." And then because Minnesota had laws that prohibited discrimination based on sex, they were able to basically be able to defeat the right of association, I guess is the best way to put it. And there's some key words that you have to look at here. And this is a reason why, like, part of me likes this case because out of this case, the court established a concept known as sanctuary, and that is where you get the sanctuary from unjustified interference by the state. That necessarily didn't apply to this case particular because they were not able to keep the women from joining based on the First Amendment right. So that being said, the reason why that happened was because they hold on one second. I'm sorry. I hate this is why I don't do a lot of live video because my phone starts ringing and my wife's trying to get a hold of me. Um so sorry about that. So as I was saying, with the thing about the JCs here in this court case is that they didn't offer they offered public accommodation and they didn't have an exclusivity to who their membership was. Yes, they only wanted men, but it wasn't a particular type of men. It was any men, any man. I guess I should say it's probably the better way of putting it. Any man. So because the the Minnesota law prohibited discrimination on the bias of sex in places of public accommodation, and the court viewed that the JCs had public accommodations, they weren't able to use that right of association. So when I talk to people, I always tell them, hey, listen, it's very important that if you are going to have an association that it is private one, and by private I mean you're not just you're not necessarily putting it out on the internet. You can advertise for membership, but you're just not letting every Tom, Dick, and Harry in. You're going to have an exclusivity to your membership, whether that is hey, we're only letting I'm live on YouTube. I got to be careful what I say so I don't get any more strikes against me. But anyways, you want to have maybe certain medical things done or not done as far as membership. So there's that exclusivity. So they saw in this case that it wasn't exclusive and that they, like I said, just pretty much let anybody in. So they actually lost on that. But as the court went through it, this is where the court, out of light of this litigation, the court established the concept known as sanctuary. And where this applies to private associations is that basically the concept holds that the government cannot unjustifiably interfere with the internal affairs of a private association, including their membership policies, internal decision making processes, without violating the First Amendment protection of freedom of association. So if a actual association is actually doing things privately and they're not breaking any laws, so like, you're not, running a brothel when you can't run a brothel in your state or that sort of thing, then the state has a hard time coming in and those associations can be looked at as sanctuaries. But the problem is most people don't do it properly. And like with the JCs, they had public accommodation. They didn't have exclusivity to who their members were. So That's kind of that case, in a nutshell. Again, I'll put more of this on the East Coast PMA site if you want to go over there and check it out. Links should be in the description. I don't know. Like I said, this is my first time going live on YouTube, so we'll see how this goes. But yeah, again, if you are watching, we have a few of you watching. Feel free to type in any comments. I am looking at the chat. I'm trying to do both here. Hopefully, this works out okay. But that being said, the next case we have, and this one kind of um, goes along with a couple other cases, and these cases have been cited a lot. Whenever you look at anything with the right of association or unincorporated associations, you're going to see these cases come up a lot because of the fact that out of these cases, there's been different things that come up. Like, this one, we just talked about had to do with sanctuary. So um, and I really got to dive into more of these cases because there's a lot of information out there that isn't right and that sort of thing. But let me see here. Let me pull up my other notes. What else do I have over here that I wanted to look at? So, and you'll see that as you start looking at some of these court cases, like, okay, so for example, this one here, the JCs had to do with discrimination of women. But then if you go over and you look at a case out of Boston in 1995, that was Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston. And basically, the Supreme Court held in this one that the private parade organizing, I cannot talk today, the private let's see, the court held that the private parade organizing committee had the right to exclude a gay and lesbian group from participating in the parade as it was protected by the First Amendment freedom of association clause. And I believe the organization committee, if I remember correctly, was, I want to say they were like veterans or something like that. And they were the ones putting on this parade. So they were saying who could be in it and who couldn't. And so you see in one case, they were able to say who can join, and in the other case, they said they had to let them join. And you'll see that a lot with different court cases going back and forth. And as awful as discrimination is, that's that right of association. So they were able to, in that case, not allow people in. But then if you look at, like, another big one is the NAACP versus Alabama and Button, I think is the other one. That was in 1958. And basically it said that, in that one, the Alabama wanted basically the list of all the members of the NAACP, and they said, "No, that is private because we're in a private association. We don't have to share that information. That would violate our freedom of association." And so they actually won that court case. So there's been a lot of different things and that you'll see, but a lot of the same things that keep coming up in cases that have failed have been that were, either unselective in who their members were, they didn't have that exclusivity, or they offered some private or some public accommodation. So, and we've seen that in Boy Scout cases. I think it was the Boy Scout versus Dale. Boy Scouts originally won, and then it got overturned because the court came back and said, no, you are offering public accommodations to anybody who ever wants to stop by and just come into your place. So, that being said, let's take a look over at Pierce v. Society of Sisters and how that kind of goes with associations. And again, none of these really are just about private membership associations or associations in general, but it kind of overlays these rights that were pulled from, or these, I don't even know the best word I want to use right now, but the the opinion of the court once these cases went through really said, okay, there's certain things that are constitutional, certain things that are unconstitutional. And when you're looking at the right of association, certain things can be done and certain things can't be done. So in this case, basically, Pierce is I think he was a superintendent of the area in Oregon or Oregon, depending on how you say it. And this was in 1925 time frame. And basically, the state came out and said, hey, they passed a law saying that children have to attend public schools, basically outlawing all of the private schools. So any of your Catholic schools and everything like that. So the Society of Sisters basically came back and said, hey, listen, this is unconstitutional. You can't do this. parents have the right to dictate where their kids go. And let me see here. I'll just read it word for word. Basically, that the right of the parent to choose schools where their children will receive appropriate mental and religious training, the right of the child to influence the parent's choice of a school, the right of the schools and teachers therein to engage in useful business or profession, and accordingly would be repugnant to the Constitution and void if that wasn't allowed to happen, basically. And so one of their arguments was that, hey, we're also, their businesses, they're set up for, well, I think one was nonprofit, but they're basically set up as businesses. And in the legal world, some corporations, not all of them, it depends on the situation, have rights as if they were a person. Because if you have a large corporation, you can't sue every individual person, but you can sue the corporation. So the corporation does have some rights, but obviously they don't have the right to like bear arms, that sort of thing, or the right to vote. So that being said, what they did is they came in as basically this society of sisters and said, hey, listen, your law is unconstitutional. It's going to cause our businesses to fail. It's going to cause the schools to fail. They own property in the area. They were very prominent in the community. And because of this law that you passed, now these children are forced to go to a public school and can't go to the private school. So at the end of the day, the court upheld and said the Supreme Court ultimately held that the Oregon law was unconstitutional. And the court held that the parents have the fundamental right to direct the education of their children and that the state cannot unreasonably interfere with that right. And we also saw a case, oh man, it's going to slip my mind now, here out of Connecticut. Oh, why can't I think of it? There was a case here out of Connecticut too that was very similar, and the court ended up going the same way because they had these precedents already set. And basically, the relevance of Peers for Society Sisters to private membership association lies in that it recognizes recognition of the right of an individual to form and join a private association and to use those associations to further their personal and collective interests. This being the school, being a private school, the court says, yes, you have that right to seek these different ways of learning. And it doesn't necessarily have to be the unconstitutional way that Oregon originally wanted to push it. So that's where this case kind of comes into this one's referenced a lot with PMAs also, even though it doesn't necessarily directly, it's not like they were a PMA themselves. Yes, they were a private corporation, but it's the court recognizing that there is an important role in fostering the individual freedoms and creativity to be able to be a part of these associations. We'll just call them for lack of better description. Um, and that things are protected under the First and 14th Amendment. So, that being said, that's that case. And again, I'm going to have more of this in greater detail. It's just hard to try to keep all my notes straight sometimes. Um, and again, it also says, some of my other note here is that the decision of Peers versus Society Sisters has been cited in numerous cases involving private membership associations, including those involving social club, religious organizations, and other groups. It has been relied upon to support the principle that government cannot unreasonably interfere with the internal affairs of private associations, including their membership policies and internal decision-making process. And basically, it has a lot to do with being having that autonomy and that self-determination and that self-reliance of becoming, joining a group. So in this case, these parents wanted them, even though it was a private corporation, they wanted them to go to this private school to be able to be trained and to learn a certain way. And that's when the courts came back and said, yeah, no, this is unconstitutional. We cannot say that all kids have to go to a public school. You can't come in and tell a parent who has a fundamental right on the education of their children where they want them to go. So you can kind of see how the opinion of the court kind of, indirectly relays this to the right of association in general when it comes to private membership associations. So let's see. Let's see. Let's see what else I want to look at here. Um, and nobody wants to jump in the chat. That's fine. Hopefully somebody does. I always love answering questions. So let's see if I can find what I was looking for here when it comes to. So one of the things, going back to, and this is where how even though this is a private corporation, the Peers for Society Sisters, and we're almost at 20 minutes now, so I'm probably going to cut this pretty short here. And I kind of like this live stuff. Maybe we'll do another live one. Let me know in the description if you want me to, or in the comment section rather, if you want me to do another live, and then maybe I'll try to schedule these so they're on a continuous, timely manner where everybody can kind of just jump on and know when it's happening. Um, so when it comes to corporations, one of the things that have been seen in a lot of cases, so you have Citizens United States versus Federal Election Commission, Santa Carla County versus Southern Pacific Railroad. Those are kind of older cases. New York State Club Association Inc. versus City of New York. That was 1988. But a lot of these cases, when you're talking about corporations, not necessarily unincorporated associations, but where I'm kind of getting off topic here, but sometimes there's misconceptions that a corporation can't be sued or it doesn't have legal rights. When you look at the definition of a person, it can be artificial or natural, right? And then if you're looking at the artificial side of things, that is where the corporations come in, and corporations, they don't have all the same rights as an individual. For example, they can't vote or bear arms, like I had said earlier, but what they can use is the 14th Amendment Equal Protection Clause. And you see that in a lot of these cases that they don't have, they're not being afforded the same as if they were an individual person because it's a legal entity as a corporation. So that's how things are seen sometimes in the legal world. And a lot of corporations have used the 14th Amendment and the Equal Protection Clause when it comes to, you know, their rights as a artificial person. So, yeah, let me know if you want me to dive into any of these topics a little bit more. I had a lot of different things I wanted to talk about. I wasn't quite sure how I was going to do it. But again, um, I just say, I just think that it's always good if you want to dive in and take a look at some of these cases yourself. Always double check what I'm saying. And if you think I'm wrong, let me know. I would love to debate and just, talk it out and hash it out with you. But yeah, thanks for watching. I hopefully you found this interesting. It was definitely different for me. I'm used to being able to, stop, rewind, cut things out, edit things. So this is a little bit different, little outside of my comfort zone, so to speak. But hopefully you found this information somewhat useful. Again, I will try to see if I can put the links to this in the show notes. I'm not sure if I can, but you will be able to find the stuff over on eastcoastpma.com. And I will also keep an eye out, putting up the finishing touches on the um, course. And here we got a question. Let's see. Are we protected by the Constitution of the United States or the United States of America on our PMA membership application? So I have a feeling this is going into more of the America is, or the United States is a corporation and it's under maritime law. I could be wrong. I'm not really sure how to answer this question. Let's see, on our PMA membership application. So everything that I do is based on the Constitution and court cases and legal standings and legalese. So, yeah, I don't know if I wrote yours. I couldn't tell you. I talk to so many people, I can't keep it straight sometimes. But if you have a PMA membership, again, that's a private contractual agreement, whatever your membership agreement says. And again, it could be written by myself, it could be written by somebody else. You could write it on a bar napkin, but it's your, as an association, your trustees getting together and saying, what are our requirements on our membership application? Or do we want to have an intake form and then decide if this person's a fit based on what our common goals are? So, I, you know, it- I don't know what your PMA membership application says, but I personally don't get into all of the, we'll call it patriot mythology stuff. I've only heard a few people talk about it really well, and that's not my forte of whether the government is a corporation and it's no longer what was signed in 1776 and that sort of thing. So, unfortunately, I'm sorry, I can't answer that question. I don't think to the way you're asking it. But let's see what else is there. I think that's all I have for today. We're hitting like 25 minutes. So unless somebody else has a question, thanks for jumping on and watching. Let me know what you think about the live feed stuff. But remember, the biggest part of this is when looking at these cases is to look for some of the keywords, and you'll see where a lot of these, some of these cases failed, but then good things came out of it. So I mean, remember, the biggest thing is no public accommodation, exclusivity, and to who your members are. And that's like the basis of operating properly. And then when you see some of these other cases referenced, you got to really dig into them and understand, like, the sanctuary from unjustified interference by the state, where that came from, how that came out of that case, and why the court established that concept and why it's needed. So thanks for listening, thanks for watching, and we'll do this again soon. Peace.